Omoyele Sowore, the convener of the protest, stating that soldiers and civil defense officers attacked the peaceful march. He also recalled that the Court of Appeal had discharged and acquitted Nnamdi Kanu, yet the government refused to release him, calling it a violation of the judicial process. Sowore said Kanu's only crime is his call for self-determination.
The court process started from the Federal High Court as well. It went to the Court of Appeal. The Court of Appeal determined that Nnamdi Kanu did not commit any offense, discharged and acquitted him in 2022. This is public knowledge. How come was he ever released on the appeal took that decision? This case went to the Supreme Court, determined that he did not violate his bail condition. Was his bail ever reinstated because of that? Never. So you cannot tell me about court processes because I know that these court processes have been violated repeatedly.
All right, my guest, Chief Festus Oguche, is still right here with me. You're welcome once again, sir.
Thank you.
Okay, so talking about the court, we would start from Kenya.
Because we can start from anywhere.
Okay. The High Court of Kenya, Nairobi, declared Nnamdi Kanu's detention and transfer, because he was extradited from their country,
Yes.
unlawful, and I think they awarded damages.
Yes. 10 million shillings.
Yeah,
Kenyan shillings. That's a lot of money.
it is. Right here in Nigeria, Federal High Court in Umuahia ordered the federal government to return him to Kenya.
That's the law.
Then the
Court of Appeal.
Court of Appeal, yes, discharged and acquitted him.
No, discharged him. The Court of Appeal did not acquit him.
Okay.
And
What's the difference?
the difference is that he could be retried on other charges, but then the discharge was sufficient. The reason why that decision was taken, it was the Honorable Justice, that fascinating lady, I've forgotten her name, that gave that decision, is because the issues of that discharge border on international law, not on domestic law.
Okay.
First of all, the court found that his extraordinary rendition from Kenya, from Nairobi, Kenya, was totally wrong and contrary to international law. It's even an international crime, which Nigeria is supposed to be prosecuted in the ordinary climb of things. I'm sure the ICC officials are waiting for that, for the go-ahead. And the judgment of the High Court, Federal High Court, Umuahia, said, you return him to that Kenya where you took him by force, where you abducted him, kidnapped him, whichever word is more appropriate. The federal government authorities did not abide by any of these decisions of the court. The Court of Appeal gave a very resounding judgment that aligns with international law. I read that judgment, that decision from beginning to the end.
Justice
and it cited authorities.
Oludotun Adebola.
That's fascinating woman. She's retired now. And she gave that judgment and said, relying on several authorities that were cited, the international law, even the International Court of Justice, that if you remove somebody forcefully from a place, you cannot try him to where you're taking him. And the crux of the matter at that time was that he jumped bail. He came and stated why he jumped bail, and that issue should also have been tried first by the Honorable Justice Binta Nyako before going into the main issue of whether he committed a crime or not. How did you bring him to this court? But it was ignored. The truth of the matter is that no law allows you to go trying somebody who was abducted from another foreign country in a circumstance that is totally unlawful and criminal.
Okay.
And the matter stopped there. We expected that after the Court of Appeal decision on the Nnamdi Kanu case, that he will be let go, even though it's just a discharge. But what happened? Malami took the case to the Supreme Court. And the Supreme Court, without looking at the intricacies of the law concerning his abduction, totally ignored it. But those are the prime issues that are and that was what established the decision of the United Nations Human Rights Council. That you cannot be a criminal. You have committed a crime and you want to try somebody on the basis of that crime that you have committed. You cannot blow hot and cold at the same time. You cannot play Jekyll and Hyde at the same time. And now the Supreme Court says he has a case to answer. They turned around and went and charged him afresh on very awkward grounds, charges that you cannot, wishy-washy charges that you cannot even put your finger on. at the Federal High Court. What sort of rigmarole is that? I think it's rather very awkward that we have a system that's been so manipulated. You begin to wonder whether you can ascribe this to judicial capture. If not, if you're a judge proper in your cause and the matter comes and you know that a citizen has been going through this kind of persecution, there's nothing wrong if you discharge and acquit him or even grant him bail.
Okay. Now, Chief Oguche, we know what Nnamdi Kanu stands for. And every government would be concerned about secession. Every government.
Yes.
So how should a government handle that? Right? Let's imagine that all that has happened with the Nnamdi Kanu case has not happened. With the calls he was making, how should any government respond to that?
That questionable. International Covenant on Civil and Political Rights is there in the Covenant on Economic, Social and Cultural Rights of the United Nations. It's there even in our Constitution. The problem is the way you go about it. The African Commission on Human and People's Rights had said in the Count Against People's case against the Republic of Zaire that it's a right that is only exercisable within domestic jurisdictions, that you cannot take it outside the sovereignty. You cannot exercise it outside the sovereignty. But there are new decisions coming up that it is a right that is basic and functionally tied to the existence of the human person as an individual before you take it to the collectivity. So it's not something that you come and think that it's something that can slam with a hammer. No. International human rights law and even domestic law, municipal law, have developed beyond the era of maybe we want to cage people. To some extent, the hard option had worked in some places, but there are such rights being agitated in places like Spain. There's one in North Africa, Morocco. There's one in there. But it just depends on how you go about it. When some persons raise that issue over the status of Quebec in Canada, what did they do? They put it to a plebiscite. The same thing with the Falkland Islands. Is it because we are in Africa? Ordinarily, what should have happened is that, oh, you want to go? Then you want to go? All right. Okay, let's put it to a vote. You fashion a method of getting this thing done. The era of lumping people in a place where they find very uncomfortable, that's gone.
A referendum,
a plebiscite. That was what the United Nations did to excise southern Cameroons from Nigeria. If not all those areas, this part of Cameroon towards Nigeria, they were all part of Nigeria. Manfe, the rest of them. They exercised that right in 1958 and they exercised them from Nigeria. So it's not a right that will now turn to a wrong overnight because some persons think it shouldn't be.
Okay.
No, now if you look at the codes that puts us together as a country, what is it? That's the Amalgamation Act of 1914. At the time they put it, they didn't say that somebody should not question it. If you go about it in a violent manner, that could attract that kind of persecution. Naturally. That it deserves. Yeah. But not when somebody is just asking for that right, for the exercise of that right.
Okay. Well, it's time for the listener to be a part of the conversation. Usually, if you are a follower of Hard Facts, these engagements between Barrister Chief Festus Oguche and I never gets to an end. So it's important that you coming now. Else, there's a whole lot more from where all of the resources come from. 0817-923-0002. 0817-923-0002 is while maintaining public order. It's with your responses to this question. 0817-923-0002. 0817-923-0003. Security agencies should stop acting as if all is well with them. Peaceful protest is allowed all over the world, and ours cannot be an exception. Thank God, Ability Atuebu says. All right. Good afternoon. Let them brandish the Court of Appeal judgments. The Court of Appeal only discharged him but never acquitted him. And the Supreme Court was held that he should be retried. So he's standing trial for the crimes he allegedly committed. My prayer is that the trial should go on speedily so that the judgment may go one way or the other. Sir Barrister Gift Choco from Eche says, all right. And this says, I can deduce that the Supreme Court is one of the problems of Nigeria. Nnamdi Kanu and River State case are references. Only God can save Nigeria, he says. Jude calls from Omuma. Good evening, Jude.
Yeah, good evening, Sam. My question goes to Festus.
All right.
The last remark he made, he said individuals or group has a right to succeed. It's not a big problem. He quoted the international laws and constitutions. Okay. But my question is, the group or the people that want to be on their own, what does the law say when they now annex other groups that do not want to go with them? What does the law say about it?
All right.
Because that's the case we're having now with Nnamdi Kanu and his group.
All right, thank you very much. Very quickly, Chief Oguche, so I take all the calls.
I didn't say the right to secede. I said the right to self-determination.
Yeah.
And in answer to his question, people who are not desirous of joining those who want to go away can express themselves through a referendum. I said it, a plebiscite. So if Nnamdi Group, for instance, they claim part of this country, parts of River State, even in Kogi State, in Benue State, they penetrated in those areas and say they are within the bounds of Biafra land. When the time comes, and of course, the United Nations will put it to plebiscite before they can make any consideration as to whether they are entitled to that status or not. They will put it to a vote, and people will express themselves. You don't just come and force people along with you and claiming territory where you have none. It doesn't go that way.
All right.
And by the way, if I can go for that, you will recall that what created this contraption, Nigeria, Togo, Berlin, Ghana, was the Berlin Conference, the Berlin Conference of 1884 to 1885, when the Europeans and their cousins met together to partition Africa in the manner they desired. They thought, they fought